Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUScast. I'm your host, Grace Gotchling. In its very first case on copyright, the Supreme Court under Chief Justice John Marshall was faced with the question of whether its own reports are protected by copyright, and decided in the negative. This term, the Supreme Court is called upon to clarify the scope of that decision, which it has not further clarified since two cases were heard in 1888. The question presented in Georgia v. Public Resource Org, Incorporated is whether the annotations to the official code of Georgia are government edicts and thus not within the scope of copyright, even though they lack the force of law. This case also raises implicit questions as to other quasi-governmental publications of which the copyright status is often surprisingly amorphous. And now, to discuss the case, we have Zvi Rosen, visiting scholar and professorial lecturer in law at George Washington University School of Law, and Cy Damle, partner at Latham and Watkins, LLP.
Hi, everyone. We're going to be talking today about the argument the court just heard, as mentioned in Georgia versus PublicResource.org, Inc. Well, the question presented is whether government edict doctrine extends to and whether it is uncopyrightable works that lack force of law, such as the annotations to official code of Georgia annotated. So very briefly, the state of Georgia puts out an official code annotated. Lexis is actually their partner that puts it out. And the annotations to the code are part of the official code, but they lack the force of law. And there's a lot of conversation at the argument about as to the nature of these annotations. And the key question is whether or not they're protectable by copyright. And this goes back to one of the very earliest cases, in fact, the earliest case for the Supreme Court on copyright, Wheaton versus Peters in 1834. That's a case that held that the opinions of the Supreme Court were not copyrightable. The court revisited this about 50 years later in 1888 in a pair of cases, Banks v. Manchester and Callahan, and really hasn't addressed it since. So this is the first time the court has addressed the government edict doctrine in about 140 years. So it's really an interesting case in that regard, and I'm going to pass it over to Cy, and then we'll have a bit of a back and forth about what happened in the case and some of the broader questions that were raised. So, Cy, over to you.
Thank you. As Wes said, I'm Cy Damle. I'm a partner at Latham and Watkins. I and some of my colleagues filed a brief on behalf of a number of current and former federal, state, local government officials on the side of PublicResource.org, on the respondent side. The perspective that we took was, there's a lot of skirmishing, and I think today's oral argument showed that, about the particular facts of this case and, the degree to which courts in Georgia cite the annotations and exactly how the annotations work in terms of how they get actually put into the official Georgia code annotated. We took a sort of broader perspective, which is to say that if the way that the question was presented in this case was whether documents that lack the force of law can be copyrighted. And the answer to that is, of course. The answer is there are lots of documents that are generated by government that lack the force of law that under any reasonable understanding of the scope of the Copyright Act and, frankly, the scope of the Copyright Clause of the Constitution ought to be available to the public outside of copyright, even though they lack the force of law. So a good example of that, and I think everybody agrees, are dissenting opinions, judicial opinions. Those are documents that, by their definition, lack the force of law. And yet we all, I think, are on common ground that a state court or a state government could not say, well, the majority opinion is free for anyone to look at, but the dissenting opinion is not, because it lacks the force of law, and so therefore we can put it behind a paywall. If you want to read the dissenting opinion of a Georgia Supreme Court decision, you have to pay Lexis some amount of money. I think everybody agrees that's not right. And so the petitioner's rule that they came in with in their petition and in their opening brief, frankly, was radically under-inclusive. And so we focused on that point, which is to say that the rule can't be really that whether a work of a state government is copyrightable or not turns solely on whether it has or does not have the force of law. And so we said, okay, well, once you accept that, then you need some sort of test to draw a line between what is copyrightable and what is not copyrightable. And the test that we proposed, which was, somewhat similar to, although somewhat we think a little better than the test proposed by the government, by the federal government, the SG's office, is that effectively if something is a work of the government that is unique to the government, so it's not the government issuing a history book or a university professor putting out an article, if it's something that is really that's core to the function of the government, then the rule ought to be that that is not subject to copyright protection. And that's for a couple of reasons. One is that the copyright law exists, and the way that what the Constitution provides is that the copyright law exists to incentivize authors to create works. It is a general exception to the First Amendment sort of principle that works ought to be free, that people have the right to say things and have freedom of speech, and it does that with the understanding that there is a reason. The reason you have copyright is to encourage authors to create work so they can get a private benefit. But there's an understanding that restricts the ability to disseminate work. A government official does not need any incentive like copyright to create the works they create. A state committee is going to create legislative history whether or not they have a copyright incentive to do so. And so reason one is you don't need copyright incentives for government officials to do the things they're going to do anyways. Reason number two is that these are all works, the works that are really core governmental works, or that are output of core governmental functions, are necessary for the public to be able to see what their government is doing. And they are kind of necessary for the public to engage in democratic self-government. And so if a state or local or municipal government could hide behind a paywall or perhaps not even release to the public at all, right? Because copyright gives you the right to prevent anyone from looking at anything, right? If a state or local or a government could say, well, you're not going to see the proceedings of our city council or the video of our city council proceedings because they're under copyright, and either we're not going to give it to you at all or you have to pay some exorbitant fee, that seems very contrary to, it's not only is it unnecessary for purposes of the copyright clause, but it also is contrary to the interests of democratic self-government. So we took the position, and I think it was reflected in some of the questioning today, that this is not something, these kinds of documents are really not something that ought to be subject to copyright. So that was the position that we took. I hazard to make predictions based on today's argument, although I think it went quite well for our side, but I'll leave it at that and happy to answer any questions.
Thanks. I think it's really interesting that I think my hazarding, I guess, is probably going to be either the position that I think is in your brief or the Solicitor General's brief, which obviously come out on opposite sides, but for both saying we should have a narrow, focused approach to this. What did you think of the argument that the public resource was argued in their brief? I know, of course, that they put out their brief around the same time that you put out yours, which made it hard to address. And I think their standard was that basically legal materials are not protected by copyright if they're put out by the government. Do you have any thoughts on that?
Yeah, I think it's a fine test. I think it's maybe under-inclusive. And I'll give you an example of one way it may be under-inclusive. So it really depends. A lot turns on what you mean by legal, right? Because everything the government does is under the law in some sense, right? I don't know that it necessarily is sort of a self-defining term. And for that reason, I favored sort of our test, which was, if it's governmental, if it's a core governmental function, if it's a uniquely governmental function, then it sort of meets that prong of the test. The problem with legal is, let me give you an example. Let's say you have state EPA is putting out a new rule, and in support of that rule, they do some kind of wetland study, right? They commission a wetland study that they then use to sort of support a particular rule that they want to put out. You'd have to argue that the wetland study, under my view, under sort of our view, I think the wetland study would count because it is something done as a sort of uniquely governmental function in service of a rulemaking and all the documents in it. Under the publicresource.org test, you'd have to say, well, is that a legal document or not? Is the wetland study itself a legal document? And you can make the argument that it's done because it's done in service of a rulemaking. It sort of is a quote legal document, but it's not the cleanest argument to make. So that was our concern when we read that about how that test might be interpreted. I think probably, just again to be charitable to publicresource.org folks, I think they had in mind a kind of broad notion of what they meant by legal documents, and so I don't think we're substantively on very different ground. It's just, semantically, I sort of preferred our formulation to their formulation.
Yeah, no, I think that makes sense. I mean, certainly I had the impression that, I'll back up a little bit and say I was a little surprised that standards didn't come up at all. I know this case is not about sort of third-party standards, but I really sort of figured that was lurking in the background of a lot of it. And I sort of figured that's why they made the argument that sort of standard, because then you can argue that, among other things, that third-party standards that are incorporated into the law are thus unprotectable. Do you think that the standard, of course, it's not what the case was about, but do you agree that the standard issue was sort of lurking there, or do you think that that's really a separate case that if it comes up, they'll get to it at the right time? Or do you think that potentially this has possibility to address that as well?
Well, certainly a lot of the amici talked about that issue. It's a slightly different issue. It's a little more complicated, right? Because these are documents that, at the time of their creation, just to give the folks on the phone a kind of what we're talking about, there are, third-party organizations that do things like put out model codes or model standards for, electrical safety or fire safety that, or, building codes, like things like that are then adopted as law by some level of government, federal, state, local government. And then the question becomes, are those codes, once they're adopted by the government, do they continue to be copyrightable? And these are documents that I think the complication comes in because these are documents that I think at their creation everyone would acknowledge are copyrightable. The question then becomes, do they lose copyright protection, or are they able to be used without fear of copyright infringement liability once they've been incorporated into law? This case involves materials that I think everyone, at least on our side, thinks that would be uncopyrightable ab initio. They would not be copyrightable from the moment of creation because they're the product of state government. And so I imagine that, and certainly in our brief, we thought about trying to take on the standards issue, and we just thought it was a bridge too far. And it was just such a different case because of what I've just explained, that we really wanted to focus narrowly on the actual issue before the court, which is, works of government. Now, that said, there probably is going to be some principles expressed in this opinion that may shed light on that question. I don't know, and I think the court is probably aware enough about it that I think they will go out of their way to say that they're not opining on that question.
Yeah, for sure. It's one of those, it's going to be sort of a tightrope for them to walk in terms of not deciding that issue, but deciding this issue. One of the things I noticed you cited in your brief was Justice Breyer's sort of tenure article from way back in the day, The Uneasy Case for Copyright. And I think it's kind of interesting that, of course, that's one of the articles that really tries to explore. There's that great old line from Justice Story that in copyright, more than anything else, the law approach is metaphysical. And this is sort of one of those cases where, like, well, is it a government work? Is this something that is being done by and for the public, or is it something that gets protection? And the actual legal basis for government edict doctrine is fairly. There's another old lawyer joke that if you say something is so basic as to not need citation, it's because you can't find a citation. And I sort of feel like there's a little bit of government edicts where, certainly the Wheaton case and then a few cases that followed, it's really, instead of looking at, it really is about basic principles of copyright more than almost anything else. And the court hasn't really opined on these sort of fundamental questions of the nature of copyright all that much in the past few decades. It's been much more sort of either questions that take on copyright from the side, or cases that are really common law cases in sort of a IP garb. And I think it's sort of interesting to see what happens with that.
Yeah, I totally agree with that. It's a very fascinating case for that reason, because you're completely right that, you look at the last say, decade of copyright cases in the Supreme Court, they've all been very statutory. It's read the statute, parse it, what does it mean? That's Aereo, that's Star Athletica, that's force of state. It's all about parsing the particular words in the act. And you have to go back pretty far to a case like Feist maybe, where they're really taking on the sort of what are the fundamentals of copyright protection here? Because you read Wheaton, you read these older cases, Callahan, very little statutory analysis, right? They're opinions that would not be written by the court today. But I think everyone acknowledges that whatever the principles were that were articulated by those courts are somehow implicitly incorporated into the current Copyright Act. But it's not like you could look at any particular amount of text. And I found it kind of interesting today that nobody even talked about the Copyright Act in today's argument, which makes this a pretty exciting case because you are really talking, as you said, about kind of really the fundamental nature of copyright. And that's certainly how we approached our brief, was not as a let's parse the statute kind of exercise, but like let's take a step back and remember what copyright's all about.
Well, of course, one time that statute was mentioned. They didn't. You're right. They didn't talk about 105 at all, which would have been sort of logical to at least mention. But they did talk about that the statute does make clear that states can own copyrights, and that was sort of a big point where we say, well, if states can own a copyright, what can they own a copyright in? And that's not, and how is it similar or different to a federal government? And that sort of was an open-ended question from a statute. And the statute, I feel like, there's certainly areas that need interpretation, but it doesn't leave a lot of open-ended questions like that. The other area where I'm kind of curious about, what I think might have some significance, is briefs that are filed by third parties in a court. And do you think this is likely to have any impact? I mean, of course, there is a lower court case holding that it's a fair use to share briefs and other court materials. Yeah. But it's kind of an interesting. I'm kind of curious to see if this gets at that as well, as sort of non-government created documents, which I guess these are. These are created by a quasi-governmental agency. Yeah, sort of. Although the state of Georgia is author under work made for hire doctrine. Right. Yeah, and just to talk about work made for hire, I think that could be a sort of a narrowing factor in this case, is that the court says, well, it's like we're going to, sort of rest heavily on the fact that Georgia was declaring itself to be the author of these works, and that matters. I don't know that it should matter, but that may be a dodge here. Yeah, and third party like government on briefs and things like that. Yeah, lots of complicated issues. I mean, as you said, fair use kind of is a useful safety valve because it's hard to come up with a theory for why those are excluded from the Copyright Act entirely, or a theory that it wouldn't be kind of wildly over-inclusive. But this comes up, it comes up, the other place it comes up is, submissions to like the Patent and Trademark Office. So you submit a patent and you submit a bunch of prior art saying like, here's like prior art that that my invention builds on. Like, are those articles, and someone wants to challenge the patent, or the patent, the patent gets litigated, to what degree are those articles now fair game or in that litigation? Lots of interesting issues there. PTO itself has struggled with it. That particular issue comes up in lots of contexts, and that one's really even more interesting because it's not
you could say, well, there's an implied license for a brief author when they submit it to the court to allow other people to look at it. That's a possibility. It's harder to make that argument when it's like some inventor submitted my article to the patent office in support of their patent application. Like, there's not the same sort of implied license argument, so then you're relying on fair use. So I think the court, I think the opinion here is going to be pretty narrowly focused on government-created works.
Mm-hmm. I think you're right. Actually, it's interesting because, of course, I was actually surprised no one mentioned patent documents either. And, of course, those are increasingly popular among interior decorators, but there's numerous precedents that are closed off from copyright. Well, if people have questions, this could be a good time for them to jump in.
While we wait for any questions, I'm curious, Zvi, do you have any questions for Sai or Sai? Any more points that you'd like to bring up? I can let you know if anyone chimes in with a question from the audience.
Yeah, Zvi, I'm curious what you thought of the sort of questioning at the end about, the state amicus brief and, the sort of sky is falling kind of policy argument, I would call it, about, well, if you don't give us copyright protection in this, we will not be able to have published compilations of our state statutes, that this is necessary for us to do that. What did you think of that? Do you think it's true? What's your sense of that, of the actual reality?
Clearly, it will change the bargaining power of states in terms of creating these documents that we can't give any copyright. It's not going to probably not going to eliminate it. I mean, I imagine creating. Listen, Lexis probably wants to create an official code Georgia annotated anyway. What it's probably frankly going to mean is less of that money going to the state. And so it's sort of a question of, to a degree, the metaphysics of copyright incentives. In that I think that the state of Georgia views this as a way to raise some money for its general fund, and Lex, and it's sort of ways of almost charging Lexis, saying yes, we'll give you this, Lexis, in return for you paying us. And I think it really depends where you think that should be in terms of do we want to, if Georgia is paying for this, should it not be copyrightable? But if it's not copyrightable, then Georgia is not going to have an incentive to be paid for it. And I mean, listen, I think that annotations will be created regardless, but there's sort of a welfareist notion of, perhaps allowing Georgia to get some of the money that Lexis would otherwise get for it. But I don't think it's going to lead to the end of annotated codes or anything like that. I mean, at a minimum, Westlaw and Lexis both need to have one. I don't know if Bloomberg is moving towards that as well, but for definitely, listen, if you have a legal information service, you have to have annotations to the code. Irrelevant to anything else. And that would actually be sort of an interesting unintended consequence. If the court holds that annotations are unprotected by copyright, and the states say, okay, fine, we're not going to have official annotations, and lo and behold, all the annotations go into pay services, where it's pretty clearly copyright infringement to copy them. I think that could be. In fact, actually, I think that'd probably be the result. I don't know if you disagree with that. I mean, if I can't copyright fees, why would I pay for them? Essentially.
I mean, so what's interesting to me is that what's sort of an interesting fact in this case to me was that, both Lexis and Westlaw have annotated codes, and so clearly there's enough incentive, notwithstanding the fact that Lexis has sort of gotten the contract for the official Georgia Code annotated, for Westlaw to come in and say, well, we're going to produce our own version of the Georgia Code annotated, which tells me that there's enough incentive, even if you withdraw from Lexis or withdraw from Georgia, copyright in their version of the OCGA. I mean, the thing that we noted in our brief, which I still think is right, is that the notion that this saves the government money is wrong. That it doesn't save, the government's funded by taxpayers, right? So what you're really boiling down to is a choice between funding this exercise through a reasonable allocation of taxes to the people of Georgia versus a more narrowly and more burdensome, frankly, essentially fee, an essential tax on those who want to see the actual Georgia Code. Or cite the version of the Georgia Code that is accepted in courts. So it's essentially it doesn't save money. It shifts the burden funding this from the people of Georgia in general to a narrower slice of people who need to see the code. And that's it's. I'm sure there are lots of people like law firms that can afford that, and it's fine to tax them specially for this. But there's lots of people that can't afford it, right? It's people that are just regular people that need legal services that have to then pay to get access to the code. And so that to me, it never struck me as like plausible that what's going on here is like a money-saving exercise. It's really about burden shifting.
I mean, of course, the other question is, would Georgia have to pay basically for access to annotations if only annotations were by third parties, and ditto other states, And I honestly don't know the answer to that and how it shakes out.
Yeah, the other thing is, to me, what the way that Lexis makes money here is, if they charge a sixth of what, according to Georgia, they charge a sixth of what Westlaw charges, and that is why does that make any sense for Lexis? Is because they benefit from having the imprimatur of the government on their product, and so it's cheaper on a copy by copy basis or subscription by subscription basis, but they make it up on volume because it's the only one that's official, right? And right. So that to me is the thing that's that makes it particularly implausible that this wouldn't happen anyways.
Unofficial annotations are already being created. I'm sure they'll continue to be created. My gut reaction is that if Georgia really was losing money and felt that this was a pointless exercise, they wouldn't be fighting so hard for it. I mean, what's Georgia's incentive to fight so hard, unless they think that genuinely that there's, that it's overall worth it to have. But, my expertise is not so much on the economic side. I can only imagine differences in that, different ways it could play out. But, it is an interesting question. I know the goal of public resource has been to make as much available online as possible. And you've really seen a revolution in legal information being freely available online in the past decade or two.
Yeah.
This decision is sort of going to give us the guidelines and rules for what the next generation of that will be.
Yeah, completely agree. This is going to be very important. There's a lot already, and I think it'll be important to foster the growth of more public availability and more transparency, frankly, of the lawmaking process, which, from the perspective of, the clients that I represented in this case, that's all to the good. The government officials that I represented want nothing more than open government. They want nothing more than having government be transparent. And at bottom, that's what this case is about. It's about ensuring that the operations of government are freely accessible and can be overseen by the people to whom they are responsible.
Yeah, I think you're right. Do you think the court's really going to do a fundamental reevaluation of some of those old cases, or if we're just going to try to sort of give? I think you're right. I think it can be sort of a narrow decision. I think you're right. But do you think we're going to see any big changes to the law after this, or it's going to be more sort of pushing the rock up the hill a little more?
Yeah, the impression I got from reading the transcript was it was very interesting to me that in the petitioner's case, when the petitioner was up arguing and when the government was up arguing, there's very little discussion of case law or questions about the case law from the justices. The petitioner, Josh Johnson, tried to inject, well, this is like Callahan, this is like Howell, this is like this case and that case, and the justices kept bringing it back to, well, explain to me, how this makes sense or how that makes sense. Let me give you a difficult hypothetical this way or that way. During the respondent's case, and especially Justice Kavanaugh, just asked a series of questions that almost had the flavor of, help me distinguish what's going on in this case from what happened in Howell, what happened in Callahan. I mean, Howell and Callahan are probably the two hardest cases for the respondent's side. So to me, what that signals is that at least Kavanaugh, where his head is there a way we can kind of narrowly sort of interpret those decisions as being, those decisions are really a product of their time, right? It's the government was very small, the justices didn't even publish the opinions themselves. The courts didn't publish the opinions themselves. It's a little bit Wild West, right? So a world where you gave people appropriate comprehensive incentives to do that work makes a lot of sense. That makes less sense today. I got the sense that they were looking for ways of cabining those cases.
I think you could be right because, well, I mean, I think Callahan is really a tough case for the Public Resource Society. Callahan was basically, he was the official reporter. He wrote annotations, and the Supreme Court said yes, those are protected by copyright. And it's sort of a twin case to Banks versus Manchester, where the court reiterated that state court opinions were also not protected by copyright, following Wheaton, et cetera, for federal. Back in the day, except for the Supreme Court, even the Supreme Court reporter was a part-time job until around then, and most other court reporters were a part-time job. Some sort of deal with the court, but you're also a practicing lawyer. The justice who wrote Banks and Callahan was a very long-time court reporter. And himself, he'd been doing it for almost 50 years at that time. And in fact, it was actually, I think he had started doing it. This is Justice Blatchford. He had started being a court reporter in, I think, the 1840s. And so he was really coming, I think he probably still had that perspective a little bit of the real Wild West days of court reporting, whereas by the 1880s it was already becoming a little more standardized. Whether the court was looking for a chink in that armor or was basically telling the Council of Public Resource, hey, you have a terrible case on your side, what are you going to do about it? I don't know.
I mean, one hopes the court is looking at this through a modern lens, right, where the cost of publication is minimal. Whatever kind of copyright incentives you may have needed for these functions, these sort of really core government functions back then, really don't exist today. I mean, I don't know. Let me ask you, how much do you think that sort of influences the court, the ease of publication in the digital age?
I don't know at all. I think that depends. I can easily imagine Breyer, for instance, looking at that. So I think some of the others would much rather say, well, we have this decision, and, it says what it says. I think even Breyer actually was interestingly very much sort of saying, I thought I knew where the line was, and you're telling me it's actually different. I sort of got a little bit of it, but he seemed a little surprised at some of public resource arguments for a broader meaning. He said, well, it's sort of annotations are one, sort of black letter all-time review vet annotations are one thing, and the decision is another.
He was the most surprising to me in all this. He had some very challenging questions for publicresource.org, which is, there's a reason we cited Breyer's article in our brief. He's generally the justice that has a narrow view of copyright. So it was surprising to see him really challenge, sort of pretty strenuously, some of the arguments being made by the respondent.
At the same time, I think Breyer especially is unpredictable, depending, his questions don't always prefigure his opinions.
Yeah.
Sometimes it's just a way of testing things. But, I think it's honestly not going to be about, I think we're going to try to say, yes, we have this black letter law, annotations are, the reporter's annotations are copyrightable, the decision is not. And we're sort of going to be a sort of, I suspect, somewhat fact-sensitive approach to this case. I mean, I don't know if we'll get a result that goes much beyond sort of semi-official documents, but I've certainly been wrong many times in my life.
Do you predict reversal, but it's because there's just a different test? What's your prediction?
I've been sort of mulling this. I don't think Public Resource gets a complete win. I think they could try to split a baby a little bit. And I'm not sure, basically saying that some of what was taken is not copyrightable, some is. I thought at the court that the state actually had an easier time, but that it's, and that sort of, makes me think maybe they'll get at least a partial win, but it's hard to know for sure. I think that the rebuttal at the end might have helped the state a little more, just saying, hey, look, they copied the whole thing.
They have to run the table, as he put it.
Yeah, I thought that was very effective. And, I think that the court might be a little put off by Public Resource having done that. Also, often in these cases, I feel like it depends a little bit on who the court thinks the bad actor is. And certainly in the eyes of, the state and publishers, George is Public Resource is a bad actor. And, I think that they've definitely been very sort of flamboyant in their infringements or use of the code. Actually, speaking of that, because, of course, there was another case argued a month ago that's probably being written at the same time. Do you think Allen v. Cooper is... Yeah. Do you think Allen v. Cooper will impact this at all?
Yeah, it was interesting that argument Justice Ginsburg had this sort of this line of questioning that was really about this case, which was, well, if the state is getting copyright in its own right, like, why is it that there was sort of a, like, isn't what's good for the goose good for the gander, right? Basically, it's like, well, if the state gets copyright, then shouldn't it also be subject to infringement damages to the extent it engages in infringement? Because it's like unfair, right? State can have copyright, can sue other people for copyright infringement, but you try to sue the state for copyright infringement and you're out of luck because of the 11th Amendment. So clearly there's at least one justice thinking about these two cases together. So I don't know, like, is there an influence in one way or the other on that? I have no idea. So it is interesting to me that there are two copyright cases involving the states. Very different legal issues, but two copyright cases involving the states in the same term. I have to imagine that at some level there's going to be a sort of some relation between one and the other.
Because I actually can't recall the last time there was a sort of state-involved copyright case for a Supreme Court,
really
in the past century.
Yeah.
I don't know. And of course, Georgia has been in the news not only for, I think Georgia signed an amicus in Allen, and of course, Georgia was also involved through the state university in the Horsepack case.
Yeah.
Which I have to think that at least some justices and our clerks are aware of, and I'm not sure how that all plays out.
Yeah, I mean, there's a sense in which, from Justice Ginsburg's questioning, it's like, this is all really unfair. Like, you're rampantly infringing people's copyrights at the same time, like, claiming broad copyright and all sorts of things that really maybe ought not to be copyrightable. So I don't know. I think, if anything, the states come off looking pretty bad in these pair of cases together. But, I'm biased.
Well, certainly in Allen v. Cooper, the justices were not subtle about their distaste for Blackbeard's law.
Yeah.
I mean, I should just explain to people who don't know. In Allen v. Cooper, it was this guy was a videographer. He was hired by to do underwater footage of newly discovered wreck of Blackbeard's flagship off North Carolina. And then the state of North Carolina basically was accused, as far as first Supreme Court, I think, essentially admitted, or at least it was undisputed, they had committed copyright infringement of his footage. And the state of North Carolina passed a law that actually called it Blackbeard's Law, that all footage of wreckage was effectively public domain. It was property of the state and abandoned, I believe. And the court really was, just so many are saying several times how troubled she was with that law. I wouldn't be surprised if Allen v. Cooper and Georgia versus Public Resource come down the same day, or very close.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.